back, everybody. As I mentioned this morning, this workshop series began in January of this year. It started with a lecture by the Ontario Chief Justice George Strathy, focusing on judicial courage and restraint in constitutional litigation throughout Canada's history. And while his paper did not touch on Indigenous rights in Canada, it was a remark he made during the question and answer portion of his presentation that did. He remarked that judges should demonstrate humility and humanity when dealing with matters involving Indigenous peoples in order to work towards reconciliation. To quote him, he said, "We ought to have the humility to recognize what we have done wrong, how to confront the issue, and to understand the experiences of the individuals who have been harmed in order to engage in a respectful dialogue to address the injustice of the past." Today, I am pleased that we are able to conclude our series with a lecture by Professor John Burrows on the topic of Section 35(1) of the Constitution, the UN Declaration on the Rights of Indigenous Peoples, and Indigenous legal traditions. Professor Burrows' biography is included in the program. There's still copies down here. I'm sure that everybody's picked one up. But I'm well aware that he has many longtime friends in the Faculty of Law here. And so I don't propose to give a lengthy biographical introduction. My own recent acquaintance with Professor Burrows came through the Indigenous Law Retreat that he has organized for a number of law schools now at his home territory at Cape Croker. I think I can speak for all of the students and faculty who attended in saying that we were incredibly grateful for what John, his family, and his community shared with us in regards to Anishinaabe law and traditions, and as well as the overall generosity of the community that we experienced. I highly recommend to faculty and students who have not yet participated to do so next year, should he still be offering the course, of course. So by way of a brief introduction, I will say that Professor Burrows is a distinguished scholar and beloved teacher. He is a recipient of a number of awards that recognize his numerous achievements, and just this week was giving the Priestley Lectures here at the University of Toronto. So I hope and expect he still has something to say to us today, and I ask you to join me in welcoming him to close out our Sesquicentennial series.
Buju Nidinue Maganidog, Ni Jinishnabeg Nichmarzig, Bangie to go in Inata Nishnabem, in Gaguji to Indishnamayan, Giganos and Dijnikas, Neashi, Nigiming and Donjaba, Nigig Dodam, Amigwech Biajayag Nungum. I'm grateful to be able to stand here today on Tattle Creek and remember the beauty of this place and the memories that I have as having been a student here and a faculty member here, and for the friends that I've made through coming to the Anishinaabe Law Camp, or those that I've worked with in various capacities. I'm also grateful to be able to speak in the context of this subject in terms of Canada's Sesquicentennial. And I want to talk about, as was mentioned, this notion of the United Nations Declaration on the Rights of Indigenous Peoples in the context of Section 35(1) of the Constitution. As you may know, over 20 years ago now, the Supreme Court of Canada created a fiction that said Aboriginal rights could only be recognized and therefore grow if they arose prior to European contact. This was the Vander Peat case. And it prevented Aboriginal peoples, it prevented Indigenous peoples from claiming constitutional rights related to practices, customs, and traditions that developed after European arrival. This idea has stunted Canada's constitutional evolution. And Aboriginal peoples have not been able to persuade the courts or legislatures, by and large, that they have constitutionally protected rights to governance, education, healthcare, justice, and so on. And as a result, we have been cut off from taking appropriate responsibility for our affairs as Indigenous peoples, because we've had difficulty proving that these activities, justice, education, healthcare, governance, were integral to our distinctive culture prior to the arrival of Europeans. We cannot shield Crown action in relationship to these areas, And so you read that 64% of the kids in care in British Columbia right now are Indigenous children. 90% of the people in prison right now in Saskatchewan are Indigenous people. The statistics just go on and on. Now, we do have the United Nations Declaration on the Rights of Indigenous Peoples, which could cause us to recalibrate and reconsider what we're doing in this field, and in fact reject constitutional distinctions based on pre- or post-contact assertions of sovereignty. I'm going to argue that UNDRIP's application to Indigenous peoples does not rest on pre-proof contact or pre-non-native, pre-sovereign assertions of non-native people. Rights, this document suggests, are vested in peoples. In fact, that's the wording of Section 35.1. Peoples are the subject. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Therefore, our constitutional document, combined with UNDRIP, should draw from the international meaning of peoples and regard us as existing within this political categorization. The exercise of these rights under UNDRIP and I would argue too under Section 35.1 should not be contingent on a non-Indigenous event, such as European contact or the assertion of their sovereignty. So Article 1 of UNDRIP exemplifies this broad-based approach. It says Indigenous peoples have the right to the full enjoyment as collectives or as individuals of all human rights and fundamental freedoms as recognized in the Charter of the United Nations, the Universal Declaration of Human Rights, and international human rights law. So the incorporation of universal human rights standards and the recognition of Indigenous law and governance is an important step in rejecting pre- and post-contact distinctions found in the Vander Peat case. There's also this companion case, which Richard talked about, the Pamajuin case. It held that Aboriginal peoples do not have the broad right to manage and use their reserve lands because any asserted right to self-government must be looked at in the light of the specific circumstances of each case, and in particular in light of the specific history and culture of the Aboriginal group claiming the right. Since in the Pamajuin case, the high-stakes gambling at issue was not regarded as being integral to our distinctive culture prior to European arrival, the Supreme Court of Canada applied Vander Peat to find that we could not claim governance over the right to economic development in that fashion in our lands in the present day. So restricting Aboriginal rights to historic analogies prevents Aboriginal peoples from governing in a contemporary context, since many governance fields will not rest on practices that were central to them when Europeans arrived. This is a form, as I've argued in other places, of constitutional originalism, which is contrary to Canada's living tree jurisprudence. Freezing the development of Aboriginal rights at the magic moment of European contact is also, as I'm saying, contrary to UNDRIP. Now, fortunately, Canada has made statements about adopting UNDRIP. In 2010, Canada passed a statement of support for UNDRIP, which stated that by endorsing UNDRIP, Canada was reaffirming its commitment to build on a positive and productive relationship with First Nations, Inuit, and Métis people, to improve the well-being of Aboriginal Canadians based on our shared history, respect, and desire to move forward. Then, in 2016, Minister of Indigenous and Northern Affairs Carolyn Bennett further announced that the United Nations Declaration would, and this is the quote, through Section 35 of its Constitution apply to Canada with this robust framework for the protection of Indigenous rights. She said, "We intend nothing less than to adopt and implement the Declaration in accordance with the Canadian Constitution. By adopting and implementing the Declaration, we are excited that we are breathing life into Section 35 and recognizing it as a full box of rights for Indigenous peoples in Canada." end quote. This full box approach should also cause courts and governments to reject pre- and post-contact distinctions in implementing Aboriginal rights. So, where's the law? Well, the minister's promise to adopt and implement UNDRIP is in a constitutional context. That's what she said, right? It's going to come into Section 35(1), puts the Crown's honour squarely on the line. As the Supreme Court of Canada wrote in the Badger case, the honour of the Crown is always at stake in its dealings with Indian people. Minister Bennett's pledge to implement UNDRIP in order to breathe life into Section 35(1) must lead the Crown to work diligently towards the fulfillment of her promises. Right? In the Manitoba Métis Federation case, the fact that the government didn't work diligently to fulfill the promises to the Métis people led to their dispossession of those lands and their diaspora, and the Supreme Court of Canada said that was contrary to the honour of the Crown not to act diligently when promises were made. As the Supreme Court wrote in the Haida case, quote, in all its dealings with Aboriginal peoples, from the assertion of sovereignty to the resolution of claims and implementation of treaties, the Crown must act honourably. Failure to advance in this way, UNDRIP, governance under Section 35, would be a serious setback for Indigenous Crown relations. Now, the role of international law in Canada's Constitution should also just play a general interpretive effect. Although international norms are not binding without legislative implementation, such norms should be relevant for interpreting rights domestically. There's the Sharp case talks about that. Other cases talk about Republic Service talks about that. While UNDRIP, therefore, doesn't have this binding effect because of its status as a declaration, it should nevertheless inform the Crown's interpretation and implementation of the Constitution. For instance, the Crown could use its powers to make arguments before the courts to directly insert UNDRIP into submissions related to Aboriginal and treaty rights and rejecting pre- and post-contact distinctions in the process. The Crown could do the same thing when developing and enacting statutes and policies to ensure that UNDRIP is the standard which animates its actions in the House of Commons, Senate, Cabinet, and ministries. And you might be aware of 10 principles that the Ministry of Justice recently promulgated that encourage and require members of the Department of Justice to adhere to UNDRIP and associated principles. When the Crown fully embraces UNDRIP's provisions, these pre- and post-contact assertions can be more readily rejected. So there is such an important part here that we need to think about constitutionalism that goes beyond what the courts will do in acting in this context. Let's think of some other provisions of UNDRIP's, Articles 4 and 5. Article 4 states, Indigenous peoples in exercising their right to self-determination have the right to autonomy or self-government in matters relating to their internal and local affairs, as well as ways and means for financing their autonomous functions. Article 5 says, Indigenous peoples have the right to maintain and strengthen their distinct political, legal, economic, social, and cultural institutions, while retaining their right to participate fully, if they so choose, in the political, economic, social, and cultural life of the state. This is something the Hawthorne Report said way back in the 60s, that Indigenous peoples can be considered citizens plus. There's a huge contrast here in what Pamajuan says and what Vander Peat would say as you look at Articles 4 and 5. Article 27 supports this conclusion. It reads, states shall establish and implement, in conjunction with Indigenous peoples concerned, a fair, independent, impartial, open, and transparent process, and here's the point I like, giving due recognition to Indigenous peoples' laws, traditions, customs, land tenure systems. To recognize and adjudicate the rights of Indigenous peoples pertaining to their lands, territories, resources, including those which were traditionally owned or otherwise occupied or used. And it concludes, Indigenous peoples shall have the right to participate in this process. So this standard, Article 27, recognizes Indigenous peoples' laws in their adjudicative processes, internally and externally, in their relationship with the broader Canadian state. Now, Canada, as arguably in the CILCO Teen case, can point to some places where that recognition of Indigenous law and governance may be implicit. In the CILCO Teen case, dealing with Aboriginal title in British Columbia, elders testified about the continuity of their lifeways. And they did this in their own language, using their own legal traditions. Indigenous law, therefore, was key in establishing a sufficiency of occupation, that is, a sufficiency of Indigenous social organization, and it went to prove title. CILCO Teen rules of conduct were central to proving that the CILCO Teen people historically and presently occupy land in the contested region. They affirmed, therefore, that Indigenous legal traditions can give rise to enforceable obligations within Canadian law. In one way, you could say social organization could be treated as a synonym for self-governance. When a nation organizes itself socially on a territorial basis and through its own laws and controls lands and makes decisions about its use and exercise and excludes others, we could conclude that such a nation governs itself. So that's the ways that there could be a questioning of the pre- and post-contact distinctions as a result of UNDRIP. But there's also another direction that UNDRIP can point, which is back home to our reserves, our communities, our hamlets, the places we live as Indigenous peoples. Article 18 says in UNDRIP, Indigenous peoples have the right to participate in decision-making in manners which would affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous decision-making institutions, end quote. So the adoption of UNDRIP clears the path for a more explicit recognition and application of Indigenous law within Canada in this internal way. As part of this development, Indigenous peoples could also implement UNDRIP in their own nations to ensure that our own people are also empowered by and protected from our own governments. In this respect, UNDRIP would be further entrenched as a part of Canada's Indigenous Constitution. UNDRIP is, by and large, an Indigenous instrument. It was created broadly by Indigenous peoples as it was negotiated for more than 30 years at the United Nations. Internal adoption of UNDRIP's principles would positively and radically challenge the calibration of Indigenous governance, particularly governance that recognizes this problematic categorization of pre- and post-contact. So rights that are found in UNDRIP, which could be available to self-governing Indigenous nations, are as follows. Let's see. The rights to the full enjoyment as a collective or as individuals of all human rights and fundamental freedoms as recognized in the Charter of the United Nations, the Universal Declaration of Human Rights, and international human rights law. Like, we should be able to claim these things in relationship to our own governments too. Under this view, it would not be contrary to the spirit of UNDRIP to recognize that Indigenous governments have obligations in relations to individuals and collectives that fall within their jurisdiction. The adoption of this instrument in this way would reinforce that view. I think it would be tragically ironic if nation states began recognizing and protecting the rights of Indigenous individuals while Indigenous governance did not take the same action. Now, in adopting this instrument, it's very important that it be picked up in accordance with the languages, the traditions, the customs of the particular nations of which it would be a part. I have a colleague, David Millward, who teaches at the University of Manitoba Law School, who's looked at sections 8 to 14 of the Charter. And he's argued that if Indigenous peoples were to apply those provisions, what goes on might in that application might look different in some respects to the way the Canadian courts apply these concepts. Just as Canada or the United States or Australia or New Zealand would pick up differently its obligations as it's implementing those instruments in recognition of the particular cultural differences, legal differences that we have amongst ourselves as nation states, so it would be the case that Indigenous peoples would frame their adoption in ways that make sense, that would be persuasive in the places that they're meant to apply. What are some of the expectations that individuals within Indigenous nations might be able to expect from their governments? Well, rights to religion, spiritual beliefs and practices, speech and expression, association, life, liberty, and security, property, family togetherness, a right not to be discriminated against by their governments, the privileges and immunities of citizenship, language, education, labor fairness, administrative law provisions like notice, fairness, hearing, healthcare, gender equality. These apply in accordance with the limitations imposed by law within Indigenous communities, and also in accordance with international law. There would be some kind of proportionality that could be thought about. In a feast house on the west coast would work one way, in the Mi'kmaq settlements, communities in the Atlantic provinces work another way. It's important to recognize that while these laws were enumerated so as to apply against nation states, I don't see a lot of good reasons for restricting their reach and not having them apply within. Now again, I just really do need to repeat this. Widespread support amongst Indigenous peoples in the drafting and ratification of this document, along with the now near unanimous acceptance of the United Nations, signals expectations that human rights, not only of communities but also of Indigenous individuals, must be respected. It is arguable that this is the case no matter the source of government authority that impacts upon these individuals. If we want to play in that field of nation-to-nation relationships, we need to get serious about how these considerations should be a part of the way we organize ourselves. I want to conclude with a short story. As was mentioned, I was able to host 3 Anishinaabe law courses at Cape Croker, the reserve that I'm from about 3 hours north of here, during September. So McGill law students came for 4 days. And then the subsequent week, University of Toronto students and faculty members came. And then we had Osgoode Hall come and join us. And judges and benchers and law professors were a part of that gathering. I had an interesting experience though. One morning, my daughter is one of my co-teachers, and we were running on the reserve. And it's a beautiful place, amazing limestone escarpments frame the backdrop everywhere you look. The water is ever present as it sort of winds in and out in those bays. There's broad stone beaches that are filled with fossils, and the sort of grasses and trees are just verdant and bright. We were running along our Prairie Road, an area where there's some grasslands. And as I was running along the road, I saw some activity up ahead, and I wondered what that was. And as I got closer, I saw, oh, there's a couple of police officers there. Maybe something's not right. And I got closer again, and I see they're holding their rifles in their hands. And so now I'm upon them, and I see that they're there with those rifles because this story unfolded in another dimension a couple of hours earlier. Nick, one of our fishers, a member of the band council, went out about 6 o'clock in the morning. And he was preparing to go pull in his nets. And so he was putting all his boxes in the boat and loading it up with gas. And he was hearing all of the splashing that was occurring in the water. And he thought, oh, he could sort of see there's like maybe a dog out about 15 feet beyond the shore. So he didn't give it a lot of thought because dogs are everywhere on the reserve. And so he just pushes out his boat and he draws close to the commotion and he thinks that it's a dog for a second, and then he notices, that's not a dog, that's a bear. And there's a bear in the water, and the bear's actually floundering. It's got its head in a plastic bucket, and it's squeezed around its neck, and it's going to drown, and it just doesn't know which way to go. So Nick applies Anishinaabe law, rescues the bear. He puts his hands over the side of the gunwales of the boat, and with some great effort, he hauls the bear into the boat. Right? So there you are, 15 feet offshore with a bear in your boat. Now, it's a smaller bear, maybe it's 120 pounds or something, but it's still got the claws, it still, can do some damage. So he pulls back to the shore, pulls the bear out of the boat to try to think about what he can do to help it, and what do you know, but the bear goes right back into the water. And there it is, swimming around, again 15 feet out. So he has to go through the same thing again, launch out, put the bear into the boat, come back. This time he thinks, oh, what can I do to help this bear? And so he's got one of those nylon yellow ropes, and he ties it around one of the arms of the bear and around the chest of the bear. Great solution, right? Pulls the bear out of the boat. Bear starts to take Nick for a walk. Right? And so they're going up and down the shore, and this bear is just full of trauma, and it's very strong, and before you know it, he's crashing through the woods. And these woods are not sort of high canopy, easy to walk through. He's getting scratched and torn, and the bear's getting further wearied as this is going on, and wouldn't you know it, but the mother shows up. You don't want to be between a mother bear and her cub, but for some reason she held her distance as Nick and the bear were walking one another in the morning. So this is at the point where I happen onto the scene. The police are standing there with these rifles. Nick is standing there with this bear on the edge of a rope, and we've called the Ministry of Natural Resources, but they're an hour and a half away down in Markdale. So what are we going to do? This bear is, it's really, really wearied, and you can tell that the trauma is just significant. I can kind of understand why they sometimes talk about bears in the circus, because it was rolling around in ways that you wouldn't think was possible for an animal. Every once in a while, it would just take a rest. And in those moments of rest, there was some implements to try to cut the bear out of the bin. And so they worked on that, and eventually they got the right implements, and they were successful. They were able to cut the bear out of the bin. Great news, problem solved, except now you've got a bear with teeth on the end of a rope. And how do you release the rope? You can't just go up and say, excuse me for a second while I untie, right? And so this bear is at the end of the rope from about here to those chairs, and the only reason Nick is safe is because the bear doesn't really want to have anything to do with Nick, right? It's just staying its distance as much as possible, and of course Nick wants it to be that way. There was one occasion, though, the bear did come and latched onto Nick. He had these fishing boots up to his knees, thick, thick rubber, went through those boots, went through his leg just like it was paper. And so this is a very serious situation now. And fortunately, the bear climbs up a tree at one point, and as the bear's resting in the tree, finally the Ministry of Natural Resources comes along, and they then take about 15 minutes because they have to judge the size of the bear, prepare a potion that would put that bear to sleep. So they get one of those long silver rods with a needle at the end with the potion, and they put the bear, they stick it in the bear, and then eventually it goes to sleep. All the while, the mother's just standing off in the distance, watching this happen. And they tag the bear. The bear, about half an hour later, wakes up, obviously taken the rope off, and the bear is reunited with its mother. So happy ending. For Anishinaabe people, when we engage in legal reasoning, we try to look at what is happening in the natural world around us and then analogize from that to what our responsibilities, opportunities, situations are that we might find in our contemporary setting, or distinguish what we see from what we observe around us. The methodology of Indigenous law is to read the earth, right? To regard the text, the resources for reasoning around the law being the kinds of things that I experienced running that morning between Anishinaabe law camps. I was able to talk to the students from First Peoples House here just a day or two ago, and they got involved in the interpretation of this story. And it was amazing to see how a legal tradition can just reignite when you put people together debating, giving their opinions, their understandings about what that story might mean and how that can address the kinds of issues that we might want to identify. In my view, that bear story is the story of what we're involved in right now in our struggle to live together better with one another, Indigenous peoples and others in this place. And I'm happy to hear interpretations you might have of this. I'm also happy to hear questions you might have about this dual thesis, which is Vander Peat should be rejected because of the United Nations Declaration on the Rights of Indigenous Peoples. Don't calibrate Indigenous rights by what was original prior to the arrival of Europeans, but also UNDRIP can be an aid for Indigenous peoples in the revitalization of our law to ensure that in that recognition process, we don't just exchange one oppressor for another oppressor, but in fact, we see a revitalization of both Indigenous law and Canadian law. It's not just Indigenous law that needs revitalizing. Miigwech bizindwe miu ahau. Thank you. So I think I can take questions for 10 or so minutes here. And I guess it's being recorded because there's a camera at the back.
A couple of questions about applying the United Nations Declaration. The first one is it provides for the rights of peoples, and there's room for dispute about how we individuate and constitute peoples, so I'm interested in your thought about that. Second, if Indigenous people are applying UNDRIP internally to ensure against, let's call it oppression from their own governments, is the adjudication of that application to be left entirely to Indigenous procedures, or is there a role for Canadian courts in policing that from a distance? And if there is, what is the role of the Canadian courts in policing it from a distance?
Yes. So the first question is, who are peoples in UNDRIP that could claim the rights to the application of this document? And I think we have to start in the messy now that we're in, which is there are 600 and some odd bands. There's multiple Métis configurations across the country. Inuit people have organized themselves in different ways. And there needs to be some incentivization of people working from where they are to think about gathering in places that would allow for more economies of scale, broader linguistic, cultural, legal traditions where you can draw upon just a wider geographic scope. And so those kinds of incentives could be put together in enabling legislation, that certain kinds of resources could be available to communities to get out of the Indian Act if there was sort of kind of action in certain fronts. That is in some ways what the Penner Committee recommended in the 1980s. It's the course that the Royal Commission on Aboriginal Peoples also counseled. It's in the land itself, as I talk about Anishinaabe law. I can go from Cape Croker on the Bruce Peninsula down to Walpole Island, around Windsor, across the top of Lake Superior and Lake Huron, out into the prairies, and still encounter Anishinaabe people. The language has its dialects, but it's got a commonality. The stories have a similarity across that distance. The cultural dimensions are very familiar across that range. At the same time, you need to be accounting for the local conditions, the local loyalties, the local elements. There's something of confederacy or federalism that Anishinaabe people could enjoy that would enable us to have that kind of a setting. There are 11 language families that Indigenous peoples have in Canada. Maybe there's things that can be done on that basis. There are regional groupings that people work within, like the Southwestern Anishinaabe, if you can't sort of pull it all together like that. In other words, there's ways to work up the scale. Adjudication, if there's a challenge to a government within Indigenous communities and UNDRIP is an operation, then that needs to be adjudicated in accordance with the dispute resolution system that is found within the Indigenous community. Otherwise, the patrolling of the broader courts would just push us to interpretations that would perhaps mirror what is generally the case across Canada, and that would defeat the purpose eventually of people being able to exercise their decision-making structures and responsibilities after that fashion. In the US context, there are tribal courts that operate all over the place. When I was teaching at the University of Minnesota for 5 years, I had a casebook of 1,200 pages of tribal courts operating around these very kinds of issues. Not only from interpreting their constitutions, incidentally, the Anishinaabe constitutions have the 7 grandmother principles in them, which I was talking about in the priestly lectures this week. Principles like love and truth and humility, bravery, kindness. These are legal principles for Anishinaabe people. And just like life, liberty, and security, the vagueness of them is both their strength and their invitation for continuing discussion about how we would implement them in those contexts. And then there's checks and balances, because there's courts of appeal on an intertribal basis that are possible. And so I think a dispute resolution system could be devised that, again, wasn't just a court structure. You could have a feast structure, you could have a peacemaking structure, you could have a kin-based understanding that included the checks and balances, that kin, real good kin governance has a part of it.
So 2 questions, and thank you very much for your talk today. second
Yes.
question. But my first question is, what does section 35.1 look like if it's consistent with UNDRIP? Is it the dissent from the dynamic right approach from Vander Peat? Is it something different? What does that acceptable legal framework look like? And then assuming, or I guess conceding, as many of us do, that under any defensible interpretation of section 35, it encompasses a right of self-government, does the charter apply, and can it, in any justified way, apply to exercises of an Indigenous right of self-government?
Okay, so I'm going to take that second question first because it actually is a mirror argument to what I was saying about UNDRIP. Indigenous peoples tomorrow, if they wanted, could say the Charter of Rights and Freedoms applies to our communities if that was their determination. And if that occurred, again, what a freedom of religion or association or mobility would look like would be articulated within the principles of that community's law. And of course they're going to be distinctive, but of course they're going to draw wisdom from other legal traditions in that exercise. And so I don't think that it has to be an either or world, but again, the charter is going to look quite different when it's taken in. And then the first question.
What does an acceptable section 35?
Yes. What does an acceptable section 35 look like? It doesn't have the justification test in it. And so we have to design intergovernmental mechanisms when we're worried about what the scope of the federal authority is, what the scope of the provincial authority is in relationship to the First Nations power. We could do treaties around that. We could create a fora where people got together and discussed. We could create agreements. We could do a cooperative. We could have an ethos of cooperative federalism. There's things that are possible under Section 35 when you take UNDRIP as the standard that have us question what colonialism is in Canada. And colonialism is the federal and provincial governments always getting the last word without the participation of Indigenous peoples. And so to the extent that Section 35.1 can go down that path of preventing that unilateralism and think about us as being a federation that respects the distinctive parts of it, I think there's a lot we can do there.
In political science, maybe more than law, the idea of at least a theoretical exit from society is deemed important, that if you really want to, you can emigrate. If DRIP is fully implemented, it gives Indigenous communities first the right to determine who is a member, and then it also gives them the right to determine the responsibilities of membership. Is there something, or will there have to be something where someone can say, I don't want to be a member of this community even if I was born into it?
Yes. So that article I quoted in the United Nations Declaration where it says people have the right to participate within and outside means that they can certainly find places of participation beyond the borders of the community. It's also the case that there would be structures to dispute and contest and change what the borders or boundaries of the political possibilities are in that instance. And there would be the opportunities through the charter type of jurisprudence that would be then taken within the community to attest the limits of that. But I think I'm dodging your question because it would have to be the case that Indigenous peoples at some point can determine what the bright lines of who's in and out of their community. And they'll make those determinations, and there's going to be people that are not going to be happy with that, and there's going to be some that will not like that they can't get out. and there's some that aren't going to like that they can't get in. And this, what I'm talking about is living with that too, but living with it in a way that has the maximum of due process, that's persuasive within the context in which it's implemented. Again, just always recognizing that there's certain things that conflict is perpetual. You're not going to wipe out conflict just by going down this path. But hopefully you're going to make conflict processes such that people are much healthier in the way that conflict proceeds, rather than self-inflicting wounds of exiting through suicide. When we were home for these camps, 4 people took their life. I only have 3,000 people in my community, right? There's a whole lot of reasons for why that might occur, but I don't want that to be the mode of exit, right? There's got to be better ways of putting together those kind of tough decisions.
Hi, I just wanted to respond to the bear story.
Thank you.
And just sort of pick up on something that was speaking to me there in it, which was a sort of a piece around urgency. That, you know, sort of differentially experienced urgency. So, you know, to Nick, being on the other end of the road to the bear, he's obviously experiencing this in a very urgent way. And the hour and a half that it took for the wildlife folks together must have felt like an eternity to him. And it sort of ties in a little bit to what you were talking about in terms of honor of the crown, because here in a conference talking about constitutional law in this context, I just sort of think of, you know, this kind of classic, like, you know, Brown versus Board of Education with all deliberate speed type of thing. Like, it's very easy for, we're probably not there yet, but even if you get the court declarations that say, okay, this is how we ought to proceed, the speed just seems really problematic. And I wondered if that element of urgency was something that came out when you guys were talking about the bear story. I'm actually just kind of curious to know what people's different interpretations were, and if that was one of the ones that was coming.
Certainly urgency was a part of what people talked about, in addition to the patience of the mother bear. Like, what was going on with that when normally there would be a charge that would take place? So people were also talking about, is the bear the First Nations, and that we need our children returned to us, and let's get us out of this place where everything is dark, and there's kind of a patient watchfulness as someone like Nick is doing the work of untangling and unraveling, and the wildlife stars are there, or is the bear actually the Canadian state? Are we as Canadians the ones with our head in this bucket, and there's things that are going on that are just leading us to kind of a disaster ecologically and socially that's not very present to us sitting in comfortable surroundings like this in a moment, but is likewise very challenging. Others said that in that bear story they saw there was those that helped and those that caused the problem. So whoever left that trash lying around, right? There's definitely things happening in our communities, more broadly speaking, that are hurting us. But then there are people that can, you know, take direct action to get us out of that as well. Some people talked about the bears being medicine, because you use bear grease when you're in different medicinal and ceremonial places. So how do we ensure that our medicine, the healing that was a part of that release, but that's a part of the bear's life, is a part of our broader community? It was interesting to see people put themselves in the different positions of the story, which is, again, the resources for reasoning around Anishinaabe law.
Time for one more.
Thank you.
Thank you. I come from a civil law country, and I'm going to ask you something that it's not making sense. Today you have mentioned. Today you have mentioned two very important and significant cases resolved by the Supreme Court of Justice of Canada. And something that is not making sense to me is why should we consider that court litigation is a legitimate, or is the legitimate way to resolve disputes state and First Nations who didn't yield soil.
Mhm.
Thank you.
Yes, so in some ways my critique is perhaps too implicit around this front to say that that's illegitimate. Vander Peat, Pamajuan, that is not in accordance with our own legal traditions. It's not in accordance with where we hope to be with international law. And even in a reformulated place of Indigenous law, we can reimagine what final resolution would look like. And in one ways, I direct us to the Maori experience recently, the Waitangi Tribunal and the settlement that allowed the recognition of the river, Wanganui River, as being a living being, having its own agency. That doesn't necessarily doesn't have to go to the court and as a final place. Your critique is, and it's well taken what you're saying. Thank you. Thank you.
I want to thank Professor Barrows for ending off our series with such an interesting talk, and I can certainly speak for myself, and I think that story was a good example of some of the things that we talked about at Cape Croker and part of that lesson, and it certainly had me as an individual sort of thinking about my interaction with nature over the years and putting that into an interesting context. So it's a really eye-opening way to look at law, and as we move forward, I think part of what we're talking about with this 150 years is that what's the next 150 years, and many people have said reconciliation is our biggest task and challenge going forward, and I think that talking about Indigenous laws is one way of us really being able to start to conceptualize the nation-to-nation dialogue that needs to go on. So I want to ask everyone to join me in thanking Joe. We have a token to thank you.
Thank you.
So I just want to also thank all of our speakers today and our moderators, Reese, Lorraine, and Carol. Today came together in a way that I couldn't have imagined. I was very pleased with how all of our panelists had such interesting papers, but I also want to thank all the people who asked really probing and interesting questions to enrich the discussion. So thank you very much, and I want to also thank, we have around the room a number of students who've been busily taking notes, and I know that they're drafting little blog posts for our website and summaries of today, so I want to thank them as well. And so enjoy the rest of Friday afternoon. It looks like it's gorgeous out there, and thank you for spending such a beautiful day inside with us.